Hello everyone, welcome back to part 2 of Law Revision series. Let's see the other chapters and other points that are left over in this part 2. Minimum members, if reduced than 6 months, then all the members will be personally liable. Exceptions to indoor management is knowledge of irregularity, negligence, forgery, no knowledge of AOA. If incorporation is done with false information, then the tribunal may order to change its regulations, liability of members to be unlimited, remove name of the company, winding up other orders that may deem fit. In case of fraud in Section 8 company, central government can revoke the license, amalgamate with other Section 8 company with same objective. See, they can play with this point. We have to carefully observe this point and add private company in front of the name of the company, and it may also order to wind up and transfer amount to insolvency and bankruptcy funds. We'll remember this point: insolvency and bankruptcy fund. Subsidiary company can hold holding company's share as before becoming a subsidiary company, can hold as legal representative. In these two cases, the voting rights will be given, or as trustee. In these two cases, voting rights will be given, but in this case, the voting rights will not be given to the subsidiary company. Coming to the next point, what all are included in prospectus? Prospectus should be dated and signed. Set such reports on financial statement as specified by SEBI in consultation with central government or SEBI regulation. Nothing should be contrary. Necessary contents of memorandum are, the short form is LOC, NAM number, that is L stands for liability, O stands for objective, C is for capital clause, N is NAM is for names of signatories, number of shares subscribed by signatories. These all should be present in the memorandum. What is shelf prospectus? One or more issue over a certain period without the issue of further prospectus is known as shelf prospectus. Issue with information memorandum. In information memorandum, we have to include financial position, changes created. No need to issue the prospectus again and again. One prospectus will be issued with the changes made in information memorandum. With this, we have to issue information memorandum with showing the financial position and also changes or charges created on the company. To file, filing with registrar, filing information memorandum with shelf prospectus, intimation of changes, memorandum with shelf prospectus is deemed prospectus. Coming to the next point, shares purchased from prospectus can get compensation. Shares purchased from market don't get compensation. This point can be played by ICI by mentioning the shareholder purchased the shares, by seeing the prospectus, how much compensation he'll be getting, will he be getting compensation or not. In the other case, if he has purchased from the market, that is will be the trading markets, then he'll not be getting the compensation in case of any false information presented in the prospectus. Abridged prospectus is a prospectus containing such salient features of prospectus as specified by SEBI. Section 447 is for fraud. Underwriting commission, shareholders should get in case of shares, they will be getting 5% maximum, or AOA, whichever is lower. The maximum is 5%. Even if it has mentioned more than 5%, he'll not be eligible for this. In case of debenture, it's 2.5% maximum, or AOA, whichever is lower. What is private placement? This question is very, very important, and also it has been asked in the examination previously for many, many times. Private placement. The previous attempt was May 24. They asked this question to selected group of persons other than public. Conditions are: issue private placement offer only 200 in one financial year, offer or invitation to number of persons, that is 200, number of issue of fresh offer or invitation till this offer has been completed, offer or invitation has been withdrawn, abandoned by the company. Till the one offer is over, the other offer cannot be made. Offer or invitation treated as public offer in case if it is made for more than 200 people. Pay off amount. Time for allocation of securities, that is 90 days if default, return within 15 days with 12% of interest. If conditions are not followed, 2 crore amount involved will be the penalty plus refund to the members, whichever is high. Next, coming to the next point, offers made to the persons whose name is recorded. No publication is required. Filing with the registrar in contravention of this section. Now let's see what is red herring prospectus. Circumstances when an expert is not liable. Having given his consent but withdrawn in writing before delivery of prospectus for registration, has no knowledge or consent and gave public notice after coming to his notice, not made by him in the capacity of an expert included, had reasonable evidence to believe. In case prospectus has not been issued but shares allocated, refund all the money. Service of documents sent to register office to company by registered post, speed post, courier services, leaving it at registered office or means of such electronic or other modes. Rules to make allotment of shares. Amount stated in prospectus as minimum should be subscribed, received by check or other instruments. Not less than 25% of application nominal value should be pending. Not rejected by any stock exchange. Even if it is rejected by one stock exchange, then the shares will not be allotted. Situation where it is irregular allotment. Company doesn't issue prospectus to the public, doesn't include matters of prospectus not filed with ROC, not received minimum subscription, 25% as per prospectus. What they are basically saying is that if in case these rules are not followed, then it will be irregular allotment. Not received minimum subscription in application, that is 5% of nominal value. Listing has been rejected by one or more stock exchanges. In these cases, we should be refunding the amount that has been received. Red herring prospectus, price per security and number of securities are left upon to be decided in post closure of the issue. Issue prior issue of prospectus. A file with registrar. Obligation under red herring prospectus is to be followed. File with registrar and SEBI upon closing of offer. These are the procedures. In this red herring prospectus, highlight new provisions other than mentioned in the prospectus. These are the obligation of the company while issuing red herring prospectus. Deposits. Receipt of money by way of deposit, loan or other form by a company which is not a deposit. Issue of non-convertible non-change of asset up to annual salary of employee if above is it is a deposit received from other as gift and invested. Is unsecured loan deposit by director if it is brought because of stipulation of financial institution by promoters themselves, not acquired? Such exemption is till the amount is paid back and not after that. After repayment it is considered as deposit. In these three cases it is not deposit, that is brought back of stipulation of financial institution by promoters themselves, but it is not acquired if they have written this in writing and then they have deposited the money. Such exemption is till the amount is paid back and not after that, then later it will be considered as deposit. Allotment should be done in 60 days. In 15 days it should be refunded. If not, then if it will be considered as deposit. Private company can make deposit up to 100% of share capital plus pre-reserves plus share securities premium. Here the securities premium will also be considered as free reserve. In case of public company, 35% of share capital, free reserves and securities premium. Procedures to accept deposit from members. This is also very important and can be asked in this May 25 and upcoming attempts. General meeting should be passed, that is ordinary resolution. Issue circular about financial position, credit rating, deposit, etc. File with registrar within 30 days. Not less than 50% of amount of deposit maturity in financial year kept in scheduled bank in a separate account is deposit repayment reserve account, that is DRR. Deposit issuance is made. Certify no default in repayment before or after this act or payment of interest on such deposits. Provide security for repayment. Not apply to private company if these conditions will not be applying to private company if which accepts from its members not exceeding 100% of aggregate of securities premium, free reserves, share capital. Startup of 5 years. Fulfills all conditions, namely not associate or subsidiary of other company. Borrowings of such company from banks or financial institutions or any body corporate is less than twice of paid up share capital or 50 crores, whichever is lower. No default in repayment. Appointment of trustee for the deposit. No company shall issue a circular or advertisement inviting unless trustee has been appointed. Written consent from trustees. Execute deposit trustee deed in DPT 2 at least 7 days before. No person including company can be a trustee if he is director, KMP, employee of the company, subsidiary or associate indebted to these people, that is director, KMP, employee of the company, subsidiary company or associate company. Material pecuniary relationship with company, entered into any guarantee agreement of debt secured, redemption of relation of these people, director, KMP, employee of company, subsidiary or associate. No trustee can be removed except with consent of all directors present at the meeting of board that has been conducted on that day. What is eligible company? Eligible company is a public company. Only public company can become a eligible company whose net worth is greater than or equal to 100 crores. A turnover is greater than or equal to 500 crores. Even if any one of the conditions are satisfied, that will be considered as eligible company. Only eligible company can get deposit from public. To accept deposit from a from public, then we have to pass special resolution below limit or and register with registrar. Not more than 25% from public, 10% from members of, this is the 10% is of securities premium, free reserves, and share capital. Here the public company can accept only up to 35%. We have seen in the previous page, we have seen the public company can accept only up to 35%, that is 25% is from the public and 10% is from members of the company. If borrowed for less than 6 months, not more than 10% in total, which is not a deposit, received from central government or state government, received from financial institutions, loan from bank deposited by government, SEBI and its subsidiaries, from public financial institutions, received against commercial paper from other company, for subscription from director written and it is not borrowed, by issue of bonds and debentures from employee not exceeding his salary, non-interest bearing amount, advance as supply of goods or services, such advance appropriate against supply with 365 days, if for legal proceedings no time limit, advance received for immovable and then adjusted, security deposit, advance for long term project. And we have seen some of the points here. We have seen some of the points here, that is bought back of stipulation of financial institution by promoters themselves, it is not acquired. Such exemption is till the amount is paid back and not after that. Then amount by Nidhi company. Punishment for not repaying loan or deposit. Company deposit plus interest plus 1 crore to 10 crore or 2x of deposits, whichever is lower. Officer in default 25 lakhs to 2 crores plus 7 years imprisonment. To receive deposit for less than 6 months, up to 10% of share capital, free reserves and securities premium, such deposit repayable after 3 months from date of such deposits renewal. We cannot issue the deposit less than 3 months, only less than 6 months in case if these things are followed, but never the less than 3 months. Amount from banks or not deposits, can accept 1 lakh rupees as deposit from its members. Foreign company. What is foreign company? Foreign company is a company which has place of business in India through agent or physically or electronic mode, conducts business in manner where main server is installed or not. B2B business, that is business to business and business to customer, data interchange, etc. Digital supply, offering or inviting offer, accepting of a deposit or a section in India from citizen of India. Financial statement, web-based marketing, advisory and transactional services, data-based online securities like telemarketing, advisory and telecommunication and medicine, education information, all information conducted by email, mobile, cloud, document management, voice or data transmission. How to create a charge? Creating a charge within 30 days, if not, plus 30 days with fees, that is additional fees. If not, then the extra 30 days, that is 30 plus 30, that is total of 60 with ad valorem fees. Who should create charge? It shall be the duty of the company creating the charge within or outside India on its property or assets, tangible or not, situated in India or not, to register signed by company and charge holder together with a fee within 30 days. Charge is public document. Assume everyone knows about it. Who is a promoter? Named in prospectus, identified in annual return, control over the affairs of company, who advice is given direct or BOD to act. The short form is PACA. We saw that is PACA, that is Prospectors annual written control over the affairs of company. Advice is given to director or BOD to act. What is dormant company? Dormant company is a company where it is done for future project, no significant accounting transactions other than payment of fees by company to registrar, payment to fulfill law or statute, allotment to fulfill this act, payment for maintenance of its office and records. Next, documents and information to OPC registration, memorandum and articles, declaration of compliance, declaration from subsidiary to memorandum, address for correspondence, particulars of subscribers, particulars of person in articles, particulars of interested person. A limited can become partner in partnership form. A company can become partner in the partnership form. Conditions for underwriting: authorized by articles, paid out of the proceedings of the issue, rate of commission, disclosure of particulars, no payment of commission, copy of the contract to be delivered to the registrar. We saw the limit. Do you remember that? Okay, let's revise it again. In case of shares, the maximum is 5% or whichever is mentioned in AOA, whichever is lower. In case of debenture, the maximum is 2.5% or whichever is mentioned in AOA, whichever is lower. You guys remember, right? I know. CS requirement, that is company secretary requirement, will be only in case where paid up share capital is greater than 10 crores and a turnover is more than 50 crores. Dividend not paid within 30 days, transfer it to unpaid dividend account in scheduled bank. Transfer to reserve after dividend not mandatory or at discretion of company. Transfer deed within 30 days. If not, company 25k and 25k to 5 lakhs. In case of the person who has been done this, he will be penalized with 10k to 1 lakh. The case should be filed at nearest high court. Declare interim dividend average of 3 years. Auditor can hold debt up to 5 lakhs. No shares can be held. Relative up to 1 lakh face value. Guarantee 1 lakh third party. Audit can only be done to 20 companies. We have seen everything in detail about audit and auditors in part 1. Sweat equity shares can issue any time after incorporation. Special resolution in general meeting with number of shares, market price and name. If listed company, permission from SEBI. Amount cannot exceed 15% of equity share capital in any financial year. Total amount issued should not exceed 25% of capital at any time. Lock-in is for 3 years. Startup company can issue up to 50%. There is no limit of 15% for startup company. It can issue up to 50%. XBRL should be filed by, that is e-form mode. Company listed, companies whose paid up share capital of 5 crores or above, turnover is 100 crores or more. All company required to prepare their financial statements under company's rules. Exemption or non-banking financial company, housing financial company, banking or insurance companies. Who are responsible to maintain books? Managing director, whole-time director, CFO, any person charged by board. These points are already seen in part 1. Let me explain it again in a short form. First auditor will be appointed by BOD within 30 days. If not, then they'll be informing to members. They'll be appointing in 90 days at EGM. till first AGM he'll be appointed as the auditor. Removal of statutory auditor, special resolution should be passed. Previous approval of central government of resolution passed within 30 days plus opportunity of being heard to the auditor. Hold general meeting within 60 days of receipt of approval of central government of special resolution. In case of government company, CNAG will be appointing the auditor if he is the first auditor within 60 days. If CNAG fails, then the right will be given to board of directors to appoint within 30 days in AGM. Then if the board of directors also fails, then the power will be given to members within 60 days. In subsequent auditor, CNAG will appoint within 130 days, that is 6 months. My god. And inform ROC in 15 days in ADT 1. In case of non-government company, the first AGM written consent of auditor of such appointment plus certificate by him or firm, notice to registrar within 15 days. Translation of documents in 30 days incorporated outside India. If not, company should will be penalized with 1 lakh up to 3 lakhs, 50k per day. See, this is the highest penalty for per day that is being charged, 50k per day. For company, it's 1 lakh to 3 lakh, 50,000 per day. Officer, 25,000 to 5 lakhs, 25,000 per day. This is in case of foreign company, right? The dollar rate are very high. That's why we'll remember in the shortcut form that the dollar price is high. That's why they're charging 50k per day and 25k per day. Equity shares with differential voting rights. This question is also very important in exam perspective. Equity shares with differential rights, the conditions are AOA, general meeting, or ordinary resolution. Listed company will be SEBI regulation. DVR rights should not be less than 74% issued shares. Track on profit distribution, no default in financial statements or annual report. Deposit of interest, default mode. In case of any default made, it should be made good at 5 years had been passed. To issue differential voting rights, has not penalized by court or tribunal in last 3 years under SEBI Act or other act. Shares are just a prima facie evidence. Forged transfer is nullity, like nothing has happened. The owner will be the same. If company acts on forced transfer and removes owner name, it should restore it and pay dividend to the owner itself. Coming to the next point, variation of rights. Consent of 3/4 of issued share, that is special resolution. Yeah, we have mentioned it. Variation mentioned in AOA or MOA and not prohibited. If variation of any share class affects other, their consent of that class of shares also should be taken. In case while changing the equity shares, if it is affecting for preference share people, we have to take the consent of preference shares members also. Minimum 10% dissented shareholders. Ask 21 days within tribunal to cancel variation, then follow their order. What is right issue? Offer accept in 15 to 30 days, can be renounced if AOA permits. If not, BOD sells not disadvantage to company and shareholder. Bonus shares can be issued only using free reserves. Conditions are AOA, recommendation of board in general meeting, no default in payment of interest, employees bonus, etc. Partly paid up if any outstanding are made fully paid up. That is, if the for 1,000 shares they have made only 7 rupees, the total value is, the face value is 10. We have to calculate like 1,000 divided by 7 into 10. Will be of course getting less than 1,000 shares, and that will be made full. Buyback of securities. It should be authorized by articles of association, special resolution. The buyback should be made only up to 25%. If it is made below 10%, then there will not be special resolution. Ordinary resolution will be enough in case of less than 10%. Buyback is up to 10% of and paid up share capital and free reserve. Buyback authorized by board resolution, completed within 1 year of board resolution or special resolution. After buyback, ratio of debt to equity shall be less than 2 or more as may be prescribed. We saw this in accounts also, that is debt equity ratio should be 2:1. It should not go less than this number. No buyback for 1 year after close of this. Prohibition is that through subsidiary company, through investing company, if a default is made by company in paying interest or payment to financial institution, banking company, only after 3 years of correcting that, it can be apply for buyback of its securities. Debenture redemption reserve. When debenture are issued by company, it should create DRR account out of profits of the company available for payment of dividend. Amount credit shall not be used for any other except redemption of debenture. Coming to the next part, debenture trustee. Company shall not issue prospectus or make offer to public or memorandum exceeding 500 subscription of debenture unless company appoints one or more debenture trustees. Written consent should be obtained in offer letter. No person can be appointed as a debenture trustee if he holds some shares, beneficiary of money, furnished another guarantee in respect of principal debts, trustee of transfer of shares. If public company refuses to register in 30 days, the transferee may within 60 days of refusal or no intimation received, within 90 days of the delivery of transfer appeal to tribunal. Tribunal order to transfer in 10 days of receipt or order, direct rectification of register and pay damages.